Hello gorgeous people, my name is Hayley Boud. I'm the founder of The Caring Lawyer. I'm a relationship property lawyer in Hamilton. Gannell Harrison Stanley Law is where I'm based, and I have specialised in contracting out agreements. So I help new lovers protect their assets. So today's talk or question is, what is spousal maintenance? And this is particularly important if you're just about to sign a contracting out agreement. If you're about to sign a prenup, as they're often called, then I recommend carefully reading the agreement to see if it mentions anything about spousal maintenance. If it does, I recommend asking your lawyer if it actually is appropriate in your circumstances. Because most likely it says neither party will bring a claim for spousal maintenance should the relationship end. That might not be in your best interests to sign such an agreement. So right now I'm going to give a brief explanation on spousal maintenance, but that's all it is. It's not legal advice. Just a quick explanation of what your rights are under relationship property law in New Zealand, just generally speaking, not advice, but I do recommend talking to your lawyer more and getting advice from your lawyer before signing a prenup that has a clause about spousal maintenance, because it might not actually be a good idea for you to sign it. Or if there's nothing in the agreement about spousal maintenance, have a quick chat with your lawyer and ask, should there be? Because maybe there should be. Maybe it would actually be better for you to have it in there. So, spousal maintenance. Under Section 64 of the Family Proceedings Act 1980, going forward, I'll just call it the Act, when a relationship has ended and one partner is unable to meet all or part of his or her reasonable needs, the other party is liable to maintain them if their inability to meet their needs is actually a result of the effects of the division of functions within the relationship while the parties live together. So if you were at home taking care of kids and the other partner is working, and now you have this inability to be able to work because you're still staying home looking after kids, but they aren't, they're able to work, then all of that will be relevant. Especially if you have a disabled child, that's going to be really relevant. So case law in New Zealand emphasises that neither party is liable to maintain the other party after the relationship has ended. So there's an emphasis on that. There's no liability, there's no right, there's no entitlement of spousal maintenance. But the Act refers explicitly to the responsibility of each party to meet their own maintenance needs. However, there is liability under spousal maintenance, and that flows from a present inability of one partner to be self-supporting. And because it's a present inability, it's usually only for a short time, usually between 6 to 12 months, just to get that person back on their feet. I did have a client who had 24 months, and that was because there was a court hearing and it was going to take so long to get the relationship property sorted that they needed maintaining during that time. In one case, this is a good example of where it might occur. The husband earned $500,000 per year working overseas, while the wife had to take care of the children in New Zealand. Obviously, she can't earn anything while she's taking the care of the kids, and as a result, she did not have the opportunity to work or study. And now the wife is unable to find work, but the husband, he's still enjoying his $500,000 per year. So there's this large disparity between the two parties. Section 65 of the Act provides guidance for the courts in determining how much to pay out when there is that disparity. The courts will have regard to the following. So here are the things that courts are going to look at before making a payment. They're going to look at the potential earning capacity of each partner. So if you haven't been able to earn because as much as your partner because you've basically put your career on hold, They'll also look at the means derived from the division of property. So by dividing the property, what are you actually going to end up with each? And they'll also look at the reasonable needs of each partner. So if you're taking care of kids and you're taking care of them all on your own, you're going to have more needs than your partner who's looking after only themselves. And you'll also look at the fact that the maintenance might be needed to support another person. So if you have a disabled child. They'll also look at the financial responsibilities of each partner and other responsibilities. So if you're taking care of your kids and they're not, then that's going to be taken into consideration. Other circumstances that the courts have looked at are the reasonable needs based on the parties' standard of living when they were still living together. So you know that you might already have this way of living that you're familiar to and your kids are familiar to. So that will be taken into consideration too. But case law shows that the paying partner will only be required to pay what they can genuinely afford. In one case, the spouse was on the benefit and was asking for $150 per week, but the court held that the other partner only had to pay $140 per week maintenance, and that was because that was genuinely all that he could afford, and he was earning $44,730 per year. So that was a little while ago, so at that time it was enough to live on. It's probably not now. So if you are about to sign a contracting out agreement, and it has a clause regarding spousal maintenance, read it carefully and ask your lawyer if this clause is appropriate in your circumstances. If you are a stay-at-home parent putting your career on hold while your partner's career is taken off and he's earning a whole lot more than what you're earning, and then you notice that in the prenup it states that you will not bring a claim for spousal maintenance, it may not actually be a good idea to sign it. Might not be recommended. It might just be recommended to maybe remove that clause in your circumstances, particularly if your children are still really young or you have a disabled child. But your lawyer, have a chat with them, ask them if that is the case for you. They ask them ask them lots of questions and ask them if it's relevant in your case or whether it should actually be removed. Because you could really be quite disadvantaged should your relationship end. However, if you're both professionals and you're both working and your careers are both taking off, then this clause will most likely be appropriate. So it may not actually be an issue, but have a chat with your lawyer anyway, or hit me up. I'm happy to have another chat on the phone or email. Just feel free to call me. I'm free. I'm available for you anytime. So lovely chatting with you guys. Thanks again for giving me your time. Feel free to ask any questions in the comments and I'll be happy to answer them. Thanks guys. Bye.